like to introduce Kieran Tapsell. Kieran is the author of this book, Potiphar's Wife, which has triggered the opportunity for this event. Kieran studied for the Catholic priesthood at St Columba's College, Springwood in New South Wales, and at St Patrick's College, Manly in the 60s, during which time he studied Canon Law for about 3 years. After leaving the seminary, he studied law at Sydney Uni. He was admitted a solicitor and barrister of the Supreme Court of New South Wales in 1973, was a partner in the firm of Watkins Tapsell from 1973 to 2004, and he's an accredited specialist in commercial litigation and advocacy, and has worked as a district court arbitrator and mediator. He was an acting district court judge from 1996 to 1999 and has been the author of many articles in legal journals on topics within his area of specialisation. Since his retirement from his legal practice in 2004, he has spent time translating Latin American literature and enjoys that challenge. And he has spent a considerable period of these last few years putting together his book, Potiphar's Wife, The Vatican Secret and Child Sexual Abuse. We will kick off first with Kieran and follow straight away with Ian. Thank you very much.
Thank you, Maria. Historically, the Church's canon law for 1500 years reflected a serious and consistent attitude to child sexual abuse. It was always a sin, but by the 4th century, the Church started to regard it as a crime punishable in this life. The first church law against the sexual abuse of boys was passed at the Council of Elvira in 306 AD. St Basil of Caesarea, the 4th century church father and the main author of the monastic rule for the Eastern Church, instructed that a cleric or monk who sexually molests youths or boys is to be publicly whipped, his head shaved, he be spat upon, he be kept in prison for 6 months in chains on a diet of bread and water, and after release is always to be subject to supervision and kept out of contact with young people. Leaving out such antiquated punishments as whipping, spitting and head shaving, St Basil seemed remarkably modern in his demand for imprisonment and for his understanding that the sex abusers are often recidivists and some form of restriction and supervision is needed. For the next 7 or 8 centuries, there was little separation between church and state, but the church still regarded the sex abuse of children as deserving more punishment than simply dismissing priests from the priesthood. In the 12th century, the church and state started drifting apart. And that's when we start to see a series of papal and council decrees requiring clergy guilty of serious crimes to be stripped of their status as priests and handed over to the civil authority for punishment. Sometimes that involved execution. In 1904, Pope Pius X decided to create a code of canon law out of the 10,000 or so papal and council decrees. He appointed a commission headed by Cardinal Gaspari, and his assistant was Eugenio Pacelli, who later became Pius XII. The commission discarded those decrees that required clergy who were guilty of serious crimes to be handed over to the state for further punishment. In 1917, the Code of Canon Law provided that those who sexually abuse children are to be suspended, declared infamous, deprived of any office, and in more serious cases shall be dismissed. There was no suggestion that they be reported to the civil authorities, let alone be handed over. 5 years later, in 1922, Pope Pius XI issued his instruction, Crimen Solicitationis, and these requirements were watered down. There would be no more declarations of infamy, and the requirements to dismiss for more serious cases had become where dismissal was available only where there was an impossibility of reforming the priest. These crimes were now to be kept secret, and the secret of the Holy Office, a permanent silence, was imposed on all information obtained by the Church in its internal investigations. Breach of the secret incurred automatic excommunication, and this excommunication could only be lifted by the Pope personally. There were no exceptions for reporting to the civil authorities. There were many reasons for this change in attitude, which I've explained in the book. The first was the idea that a priest had become ontologically changed by God at ordination was gaining popularity within the Church. In 1905, a French priest, John Vianney, who proclaimed that after God, the priest is everything, was beatified, and he was canonised in 1925. You can find concrete expressions of this theology in the attempts by the Holy See around the 1920s and thereafter to negotiate concordats with sympathetic Catholic countries, whereby convicted priests would not spend time in jail like ordinary criminals, but would spend it in monasteries. Secondly, the Church had become obsessed with a loss of faith through scandal, and this could be spread by the new invention of radio. The first commercial licence for a radio station was issued in 1920. One solution to the scandal problem was to cut off the information at its source. The third reason is that by 1922, there had been decades of anti-clericalism in Europe, starting from the time of the Reformation and the French Revolution. In 1922, the Church may have had some legitimate reasons to fear that in some countries, priests may not receive a fair trial. The fact is, however, that from that time onwards, there was an official policy of cover-up of child sexual abuse amongst clergy. It was enshrined in canon law, and it continued long after these anti-clericalist problems had disappeared. The pontifical secret over allegations of child sexual abuse was confirmed and expanded by another 5 popes after Pius XI. Pius XII, one of the architects of the 1917 Code, continued Crimen Solicitationis. In 1962, Pope John XXIII revised and expanded it to cover priests who were members of religious orders. In 1974, Paul VI issued the instruction Secreta Continere, which replaced the secret of the Holy Office with the pontifical secret. It was the Church's top secret classification, and it was extended even to cover the allegation. There were no exceptions for reporting these crimes to the civil authorities. In 2001, Pope John Paul II expressly imposed the pontifical secret again in Article 25 of his apostolic letter Sacramentorum Sanctitatis Tutela, when he introduced some new procedures for dealing with sexual abuse. In 2010, Pope Benedict XVI revised these procedures and expanded the reach of the pontifical secret to cover priests who sexually abused intellectually disabled adults and who had in their possession child pornography. That's only 4 years ago. In 2010, the Vatican announced that it would dispense with the pontifical secret where the local civil law required reporting. The pontifical secret on all allegations and information about child sexual abuse is still imposed by canon law where there is no civil law requiring reporting. And as I have explained in the book, there are very few countries and states that have such reporting requirements for the vast bulk of sexual abuse allegations. In Australia, only New South Wales and Victoria have such legislation, and Victoria only had that legislation about a month ago. There have been a number of statements made by church spokesmen that the pontifical secret did not prevent bishops from reporting these crimes to the police because, they said, it only applied to the church's internal investigations. Well, of course it only applied to them. But from where did the church get its information? It first received an allegation. Prominent canon lawyers like Professor Beale from the Catholic University of America and one of the authors of the new commentary on the Code of Canon Law, and Professor Gerardo Núñez from the famous Faculty of Canon Law at the University of Navarra, state that the pontifical secret applied to the allegation itself, as well as any information obtained through any investigation and trial. Sister Elizabeth Delaney, an Australian canon lawyer, confirms this in her doctoral thesis. Dr. Roger Austin, another Australian canon lawyer, told the Canine Special Commission that a dispensation was necessary to reveal to a civil court any information obtained in a canonical investigation. If you need a dispensation, it must be forbidden. Professor Beale has called the pontifical secret a stupid law and said it even prevents a bishop telling anyone whether the priest has been found innocent or guilty after a canonical trial. Sister Moya Hanlon, another Australian canon lawyer, recently confirmed this at the Royal Commission in the Nestor case. Other spokesmen have said that the pontifical secret was never intended to frustrate or undermine any civil investigation or prosecution. But there will be no civil investigations or prosecutions to be frustrated if the police do not know about the allegations. The pontifical secret did not prevent a bishop from going straight to the police if he walked into a priest's bedroom and found him sexually abusing a child, because his knowledge came from his own eyes and not what he was told from a canonical investigation. But how often did that happen? Probably never. In the common law system, civil lawyers are guided by the decisions of courts on the meaning of the law. In the canonical system, the same function is carried out by the legislature, that is, the Pope and the Curie congregations. Further guidance can come from canonical scholars. These Curia congregations have confirmed that the pontifical secret prevented reporting to the police. In 1996, the Irish bishops asked the Vatican to comment on their proposals for mandatory reporting. They received back a letter from the Congregation for the Clergy stating that their proposals for mandatory reporting gave rise to serious reservations of both a moral and a canonical nature. The congregation also threatened that if they reported priests to the police, any canonical procedures against them could be set aside on appeal to Rome. Some 3 months after the pontifical secret was again imposed in 2001 by Pope John Paul II, Cardinal Castrillon, his prefect of the Congregation for the Clergy, wrote to the French Bishop Piquin, congratulating him for not reporting a serial paedophile to the police. Bishop Piquin was given a 3 months suspended jail sentence for breaching French law on reporting. Castrillon told him that he was sending a copy of the letter to all the bishops of the world to tell them how to behave. Don't report paedophile priests to the police and go to jail if need be. He later said that his letter was authorised by Pope John Paul II himself. In 2002, again this is just a year after the reimposition of the pontifical secret, the American bishops asked the Vatican to change canon law for their country, to allow the reporting of all allegations of sexual abuse by clergy. Half the American states had reporting laws, which meant that these bishops could be going to jail if they observed the pontifical secret. Cardinal Ray from the Congregation of Clergy told them their proposals conflicted with canon law. A delegation of bishops went to Rome for a meeting and a compromise was reached. Reporting was permitted, but only where there was a civil law requiring it. The Vatican was more concerned about the bishops going to jail than the welfare of children. In 2002, again, this is just another year, the same year after the confirmation of the pontifical secret, 2 cardinals and 2 archbishops from the Roman Curia and 1 judge from the Holy See's highest court stated publicly that bishops were not to report accused priests. 4 other cardinals, not members of the Curia, said similar things. Cardinal Rodriguez Maradiaga, who is now in charge of reforming the Roman Curia on behalf of Pope Francis, also said that a bishop should be prepared to go to jail than report a paedophile priest to the civil authorities. Now, bearing in mind that the Vatican is the supreme interpreter of canon law, not like in our system where it's the courts, it is very clear that secreta continere meant exactly what it says. Any allegation and any information from the church internal inquiries cannot be reported to the police unless, since 2010, there was a civil law requiring reporting. In 2012 and 2014, the Italian Catholic Bishops' Conference stated that its members will cooperate with any ongoing police inquiry, but they will not be reporting any allegations against priests to the police. because Italian law did not require them to do so. That attitude is totally in accordance with canon law as it currently stands. The exception for reporting only applies where there is a civil law requiring reporting. On the 30th of September 2013, the Australian Church forwarded to the Royal Commission a 207-page submission. Francis Sullivan, the CEO of the Truth, Justice and Healing Council, described it this way: "It's the most comprehensive document ever produced by the Church dealing with child sexual abuse. It is a warts and all history," he said, "going back many decades. None of the history I have just mentioned to you appears in that 207-page submission. There is a special section on canon law dealing with the accused, and over 50 references to canon law. But the pontifical secret, the biggest wart of all, is never mentioned." The submission also has this very carefully crafted sentence: "There is nothing in the 1983 Code that is in conflict with any applicable civil law obligations relating to the reporting of allegations of child sexual abuse." I'll repeat those first few words. There is nothing in the 1983 Code. That statement is true because the secrecy provisions relating to child sexual abuse are not in the Code. They are in Sacramentorum Sanctitatis Tutela, which invokes secreta continere. Neither of them are part of the Code, but they are part of canon law. The submission even says that Sacramentorum has the force of canon law. Further, the submission makes no mention of the fact that the conflict between canon and civil law over reporting was only removed 4 years ago in 2010, when the Vatican announced that it would be issuing instructions to obey civil laws on reporting. The same limited extension or concession that it gave to the United States 8 years before in 2002. As I've said in the book, there is not one cover-up, but two. And the second, the attempt to hide the responsibility of 6 popes for the first cover-up through canon law, is still going on right now in front of our eyes. On 2 occasions now, in January and May this year, the United Nations Committee on the Rights of the Child and the Committee Against Torture have demanded that the Church abandon the pontifical secret and impose mandatory reporting under canon law. On the 26th of September 2014, this is just last month, the Holy See provided its response. It rejected those demands. It stated that in signing the Convention on the Rights of the Child, it only had responsibility for the handful of children who live within the 44 hectares of the Vatican City. It said it had no obligation and no capacity to impose principles under the Convention upon local churches and institutions, because it said, they're governed by national civil laws. It said that attempting to impose conditions on local churches worldwide would constitute, I quote, a violation of the principle of non-interference in the internal affairs of states. This newfound sensitivity to the sovereignty of states is in marked contrast to the conduct of the Holy See from 1922 to 2010, requiring bishops to breach any civil law on reporting. Now it is dragging up national sovereignty as an excuse for not imposing mandatory reporting. The national sovereignty of a country would only be infringed if canon law required mandatory reporting and the civil law forbade reporting. No such country exists. The Church in Australia, both before the Victorian Parliamentary Inquiry and the Royal Commission, has rightly supported the idea of mandatory reporting of all allegations of sexual abuse while recognising the rights of victims not to report. If civil law ought to be changed, in their opinion, to reflect that policy, it is impossible to understand why canon law cannot also reflect it. Pope Francis's refusal provides ammunition for critics to say that the Church fully intends to continue the cover-up of child sexual abuse in those countries that do not have adequate reporting laws. And that is likely to be in the underdeveloped world that does not have the money for royal commissions. A large part of my book explains that the second reason for sexual abuse by clergy going unchecked was because the Church's internal disciplinary system was hopeless. Canon law required that before a priest could be dismissed, every effort had to be made to reform him. The 1983 Code of Canon Law also imposed a 5-year limitation period on bringing an action to dismiss a priest. Children were expected to complain within 5 years of the abuse, because if they didn't, then the canonical crime was extinguished. In 2001, that period was extended to 10 years from the 18th birthday of the victim. And in 2010, it was extended to 20 years, but they were not made retrospective. You can imagine the number of priests who were able to escape prosecution under the canon law because of that. Prior to 1983, there was no limitation period. Well, why do they need one now? Canon law also provides what I've called the catch-22 defence. A priest cannot be dismissed for pedophilia because he is a pedophile. Two of Ireland's most notorious pedophile priests, Father Tony Walsh and Father Patrick McGuire, were dismissed by a Dublin canonical court. The appeal court in Rome set aside the dismissals because, they said, they'd been diagnosed as pedophiles. They couldn't help themselves. Canon 1321, that provides this defence, has not been changed. You can look it up yourself. The more children a priest abuses, the less likely he will be dismissed. Society has as much interest in not having sex abusers amongst priests, ministers, imams and rabbis as it has in not having lawyer thieves and drug-dealing doctors. Disciplinary proceedings against these professionals are open to public scrutiny. The churches dealing with its priests are not, because of the pontifical secret. On the 19th of March 2014, Pope Francis said that Pope Benedict had supported zero tolerance for clergy who sexually abused children. On the 27th of May 2014, he promised that he would apply the same zero tolerance standard. The legal profession in many jurisdictions has for decades adopted a zero tolerance for certain kinds of professional misconduct. Solicitors who steal from trust accounts are struck off the rolls, and at least in my experience, it might be different here, but at least in my experience, they are never allowed back on. That is what most people, I think, understand by zero tolerance. On the 6th of May 2014, the Holy See produced figures to the United Nations showing that more than 3,400 credible allegations of sexual abuse of minors had been referred to it since 2004. As a result, 848 clerics had been dismissed, and other disciplinary measures had been applied in more than 2,500 other cases. We don't know what these disciplinary measures were, because they won't tell us. But the Vatican's Guide to Understanding Basic CDF Procedures provides that where a priest has admitted to his crimes and accepted to live a life of prayer and penance, the bishop may issue a decree prohibiting or restricting the priest's public ministry. It is only if he violates these conditions that he can be dismissed. The Church's figures establish there was no zero tolerance during Benedict's pontificate. There was a 70% tolerance, and struck-off solicitors were only stealing money. These priests were stealing the lives of children. But returning to mandatory reporting, on the 26th of July, nearly 25 years ago, Dr. Nicholas Tonti Filippini, a Catholic ethicist, said to the Australian bishops, "For the sake of the Church, reasonable suspicion of a crime must be reported to the authorities. Any attempt to contain it within an in-house investigation and management risks bringing the Church into disrepute." It took 20 years for the Australian bishops to have that written into Towards Healing. But at least it is there now, even though, in my opinion, it's in breach of canon law. Dr. Tonti Filippini's prediction has come true. The Church has brought itself into disrepute and will continue to do so long as mandatory reporting of all cases is not required by canon law. The Australian Church is to be commended, I won't be long, is to be commended for its efforts since 1966 to find ways around canon law and for developing protocols which often defied it. But it has now spoiled its copybook before the Royal Commission by failing to acknowledge the role of the pontifical secret and those responsible for it. On his appointment as the new Archbishop of Sydney, Anthony Fisher said, "The Church can do better. No excuses, no cover-ups. I don't think people want spin." And I think that's quite right. But that is what we've been getting. When the Royal Commission calls for submissions on reporting, let's have a real warts and all submission from the Australian Church. Forget about this paltry excuse that the Church was on a learning curve. There was no learning curve about child sexual abuse being a crime. Forget about the nonsense that the Church succumbed to the theories of some psychologists in the 80s, and that's why bishops tried to reform these priests. That requirement was written into canon law before these psychologists were born. Forget about blaming the problem on the sexual liberation of the 60s. That might explain why most abuse took place in the 70s, but the cover-up was enshrined in canon law in the 20s. and stop blaming dead and elderly and ailing former bishops when you knew that they were prohibited from reporting these priests to the police and that canon law was useless in getting rid of them. And above all, acknowledge the damage done to the children by the imposition of the pontifical secret, and have the courage to criticise Pope Francis for not agreeing to the proposals of the United Nations. If Catherine of Siena can pull a pope into line, then you can too. In 1986, Raymond Mouton, a lawyer working for Father Thomas Doyle to develop a child sex abuse protocol, told a meeting of canon lawyers in Washington, the Church cannot credibly exert moral authority in any area where the public perceives it is incapable of maintaining moral authority internally. The Church's internal moral authority in this country has been undermined by its failure to be frank to the Victorian Parliamentary Inquiry and to the Royal Commission. But it's not too late. The Commission has 2 more years to run, and as a tribute to Gough Whitlam, let me say, it's time to come clean.